Hear ye, hear ye. I'm Chief Justice and Justices of the Supreme Court of the State of Michigan. All persons having business with this honorable court are admonished to draw nigh and give their attention to the court is now sitting. God save the United States, the State of Michigan, and this honorable court.
Okay, good afternoon. This is the afternoon session of our first day of our March call, and the first of our two cases, both of which are applications for leave, will be Nexteer Automotive Corporation versus Mando America Corporation.
May it please the Court, Mary Masseron and John Bursch on behalf of Mando. I'd like to reserve 4 minutes for rebuttal, and I understand I'll need to manage my time. May it please the Court. Nexteer filed this case to harm its competitor Mando and to scare other Nexteer employees from leaving the company by seeking to enjoin recently departed employees from working. To maximize its threat, Nexteer ignored the non-disclosure agreement's arbitration clause and filed in court, where more intrusive and far-reaching discovery was available and all proceedings would be public instead of private. Nexteer sought preliminary relief so it could invoke the exception to the arbitration in the non-disclosure agreement, a fact it emphasized by underlining the relevant language in the arbitration clause and attaching it to the complaint. But after those preliminary proceedings were over and the business court had determined that Nexteer was unlikely to succeed in identifying actual trade secrets, Nexteer refused to abide by the arbitration clause it had drafted and signed. In this context, the business court handled Mando's arbitration request exactly the way you would expect. It concluded that Mando had not waived its right to arbitration, and it applied the rules set forth in the Restatement of Contracts Second at Section 84.2 and Williston, Section 3920, and held that any Mando waiver could be revoked in any event unless Nexteer could show prejudice. And the business court found, as a matter of fact, that Nexteer was not prejudiced by its duplicitous conduct. This court should reverse the Court of Appeals and reinstate the business court's opinion. That opinion is consistent with Michigan contract law, dozens of decisions from around the country, and the plain text of the Michigan Uniform Arbitration Act. First of all, the court asked us to address the question of whether prejudice is required in the context of an express waiver. It's our position that prejudice absolutely is, because of the strong policy favoring arbitration agreements enforcement. The Michigan Court of Appeals has required prejudice in any number of cases. Overwhelmingly, the federal courts and state courts from around the country agree. And decisions demonstrating that are set forth in Mando's supplemental brief at pages 19. Consistent with the principle that contract waiver can always be retracted absent prejudice, Williston in Section 3920, the Restatement of Contracts in Section 84.2, the UCC Section...
Counsel, good morning.
Good morning.
First off, it's always a pleasure to have you here at the court. We always enjoy hearing from you. Just a quick question, looking to the case management order that was entered into, when one gets a case management order and ultimately kind of starts pursuing that case management order, isn't that like a true sign that litigation has commenced?
Certainly, litigation has commenced with the filing of a complaint, and the case management order here was intended to provide the parties preliminary thinking about a number of issues. But I think it's important to note that the case management form did not, the waiver box for arbitration was not checked. In fact, there was a box that would have indicated waiver. Unequivocally, that box was not checked. The business court recognized that in its decision. In addition, at the time that the case management order was discussed with the parties, they were engaged in preliminary injunctive proceedings, and the arbitration clause had a carve-out for such proceedings. Nexteer even underlined that provision when it filed its complaint. Moreover, the Michigan Uniform Arbitration Act allows parties to courts to grant preliminary relief in the context of arbitration. And that is why the trial court authorized discovery on only one issue. Yes.
I can only, in reading the trial court's resolution of this issue, say what he said. It's, with due respect, the court finds the arguments advanced by Mando disingenuous, highly skeptical of all the arguments advanced that this was not a waiver. It ended, however, and said, however dismayed, the court recognized that an effective waiver requires not only knowledge of an existing right to arbitrate, which the judge nailed Mando on. They knew it because they attached it to the initial pleadings, that an act's inconsistent with that right to arbitrate, but also prejudice resulting from inconsistent acts. So it seemed to me that the linchpin of the trial judge's determination in favor of arbitration here was his legal determination that prejudice was required and it wasn't shown. Don't you agree?
I do think that was the linchpin. I would also point out...
What if that is not this court's conclusion, that an express waiver, as opposed to an implied or an imputed one, does not need a showing of prejudice to be effective?
Mando has argued, and I think correctly so, that the checking of a not applicable box...
That's a different question entirely.
I'm sorry, I thought you were asking
My
about
question
the facts.
is simply this. The Court of Appeals determined, and the cases, the Court of Appeals cases are startling for their lack of attention, their conflation of principles about the difference between the waiver that is by estoppel, an express waiver, an implied waiver. They've just put them all together. These are not very coherent. This is a body of cases I find very coherent. So if you start disaggregating and trying to figure out doctrinally what the distinctions might be between a party that says, I waive this right, versus the court imputing a waiver, I'm trying to understand why in the world, when we have a voluntary and knowing relinquishment of a right, an express waiver, we would require, notwithstanding, a showing of prejudice.
Let me try to answer that in a couple of different ways. First of all, Mando argued, and we agree, that the case law discussing these various categories and subcategories is confusing, to say the least, and that is why we urge the court to adopt a single rule, which is waiver, whatever rubric you want to categorize within that doctrine, should have a showing of prejudice.
Why? Why?
Here's the reason why. Because when you have the Michigan Uniform Arbitration Act, which has language in it which talks about contracts, arbitration contracts being enforceable unless the parties show that the contract itself is revocable on legal or equitable terms. If you put that in the context of arbitration, and you put it in the context of the waiver cases...
Counsel, I can waive my constitutional right. And you're saying I can't waive a contractual right that might be protected by a statute?
The legislature has said, absent a showing that the contract itself is revocable on legal or equitable grounds, then it's enforceable. And here, the legal and equitable grounds that might apply in the arbitration context and in the waiver context...
So once I'm in it, I can't waive its application according to your construction of the...
You could waive it in two circumstances. You could waive it, as this court found, in the context of an oral modification where there's a meeting of the minds in quality products. We don't have that here. It hasn't been argued, and the facts wouldn't bear it out.
Or I can't unilaterally relinquish a reliance on arbitration, is what you're saying.
If you unilaterally relinquish it, you are entitled to rescind that. That's what the restatement says, that's what Williston says, that's what Farnsworth says, unless the other side has been prejudiced. And if you put that in the context of the statute, what that means is where you can show that the provision, the contract provision, the very purpose of it has been frustrated, or it is no longer possible of performance, in that circumstance, then it is proper for a court to enforce the waiver.
So your argument is that the federal policy, which that's a question here too, whether federal law applies, I'm not sure it makes any difference, but it might. The federal policy favoring arbitration and the state policy favoring arbitration is so strong that a valid arbitration provision in a contract cannot be waived, or it can be waived, but nonetheless the waiving party may stand on its right to arbitration unless there's prejudice to the other side.
That's correct.
And so that would be contrary to most other kinds of contractual waiver, and the reason we would distinguish it is because of this strong policy favoring arbitration.
I would say we can distinguish it because of this strong statutory policy favoring arbitration, but I would also say if you look at Section 3920 of Williston, if you look at the restatement, Section 84, Sub 2, if you look at Farnsworth's general discussion, all of those scholars speaking about general contract principles say that a contract provision, if waived, may be retracted in the absence of prejudice. So it seems to me...
So in other words, if Justice Viviano and I had a contract and we said, I'm going to sell you this cup of coffee, and then he says, I waived my right to your cup of coffee, so I take it back, and then he says, wait, I want my cup of coffee, and I say, oh, all right, well, no prejudice, I was going to give you the coffee anyway, then he can change his mind, yes?
I'm not sure in the context of a unilateral offer and acceptance, which is your hypothetical, exactly how it would be applied, but let's say you have a contract to sell...
Well, I assumed there was some consideration. I'm sorry. He was going to give me $1.
Okay, so he gives you $1, and you give him the $1, he gives you the coffee, then you say, I waive my right to the coffee. Then you give it back. Then you say, wait, no, I'd like it back. If he's destroyed the coffee or resold the coffee and he doesn't have more coffee, then he's prejudiced. He can no longer perform, so the court is not going to enforce it. But if he's standing there with the coffee and he's got the consideration and you change your mind under our theory, he would have to give you the coffee.
Has any court applied the expert treatise authors that you just mentioned? Has any court applied those principles in the context of an express waiver of an arbitration provision, or are you inviting us to be the first one?
I'm inviting you to be the first one in Michigan. I know there was at least one of the cases cited, and I'm sorry, I can't recall it off the top of my head, in which the
so even though
contract provisions were discussed.
All right, so you want us to be sort of on the cutting edge.
I should say, if you look at the overwhelming weight of authority around the country in the context of arbitration clauses, the courts are routinely requiring prejudice, and they are requiring it in whatever waiver context. They don't always hook it to the language of the statute, some courts do, and they don't always hook it to this retraction of a waiver.
But Counsel, I have a question.
It has been done around the country in some
Counsel,
cases.
I have a question, and I appreciate what you're saying. I guess my question is, could one argue that there's a natural prejudice that kind of exists as it pertains to the fact that you're changing in a lot of ways? If I have a case management order and I'm ultimately operating off of a CMO, is it possible that one could argue that you have a natural prejudice that's kind of built in terms of the cost, effort, time, resource that is dedicated to the preparation for trial or to the kind of trial issues that you're going to have before you go into an arbitration circumstance?
I'm conscious of the time, and I want to save rebuttal, but let me try to answer that very quickly and then sit down so we still have rebuttal time. It seems to me in this case, first of all, the business court found no prejudice. That's a factual finding that we believe should be deferred to. Secondly, in this case, the case management order was at a very preliminary stage of proceedings. The Michigan court rules, which permit amendment of complaints and answers, have a policy of liberal amendment. So these preliminary proceedings, which the business court talked about as being in an embryonic discovery state, still not having emerged from the pleading stage of the case, it seems to me there isn't prejudice, and the business court was correct about that. If I may, I'll save the rest of my time for rebuttal.
You may.
Good afternoon, Your Honors. May it please the Court. John Birmingham appearing on behalf of Nexteer Automotive Corporation. The first question that the Court asked is, does an express waiver require prejudice? Our answer to that question is no, and from our perspective, it's a non-controversial answer. All we're saying is the Court should hold a party accountable for what it agrees to in a stipulated order, and if it agrees to a relinquishment or an abandonment of its rights in a stipulated order, the Court can hold the party accountable to that without any further inquiry. I don't think that is particularly controversial. And if you look at the cases, just to kind of give the legal landscape of the cases, Your Honors, let's be clear. There's no Michigan case and no case cited outside of Michigan where any court has found express waiver and has required prejudice. There's no case. They've been cited one, and there's no case out there that says that. Anytime the court finds express waiver, there is no requirement of prejudice. Every case in Michigan and elsewhere where the court has required prejudice is premised on the fact that they have to infer waiver. If you look at the beginning of every case, it says waiver of arbitration agreements is not lightly inferred, and then they go to each one of the three factors after that. And if you look at it, Your Honors, too, when they go to the three factors, none of the three factors are, did a party intend to waive their rights? Okay? They are, did the party have knowledge of the arbitration agreement? Did they act inconsistently? And was there prejudice? If those three factors were really meant to apply in situations where parties intended to waive their rights, that would have been one of the factors. Counsel, did you intend to waive your rights? Yes or no? That would have been one of the factors. The absence of that means that that was not intended to apply to express waivers. I want to address also briefly the issue of...
well, let me ask you the question.
Yes.
Is this an express waiver? And is that a factual determination or a legal determination under these circumstances?
And I think that's a good question, Justice Young. The answer to that question is yes, it is an express waiver because a waiver is an intentional relinquishment or abandonment of a right.
Well,
okay?
This is a little more variegated. This is a forum that had a waiver, an express waiver box.
Yes.
But had another one added by virtue of the colloquy among the parties. Yes, there is one, but it doesn't apply.
Yes.
That was not a part of the original form. That was added, was it not?
It was.
Okay. So, I mean, your opposing counsel says, well, it's not express because we didn't do the express waive, but they did something else. So I'm asking whether it is ineluctably clear, without the trial court making that determination, whether the checking, we have an arbitration provision, but it doesn't apply here, is an express waiver.
I have a legal and a factual explanation for that.
We don't do facts here, though.
Do the factual one?
If you do, but I don't make fact findings.
Right. Well, actually, that's an important point, Your Honor. You brought this up. The same court that actually drafted the case management order made the factual determinations, and that court rejected each one of the arguments that plaintiff is making.
Did the court ever make a finding?
Defendants are making.
Did the court ever make a finding, the trial court, that there was an express waiver?
The trial court, no. Actually, the court was not that specific, Your Honor.
Right. So that's why I asked
yeah.
the threshold question. Do we have an express waiver, and how do I know? And who gets to decide?
The answer to that question, that's a legal determination, And what you need to look at is there evidence of an intent to relinquish or abandon rights? And when a party is asked the question, does an arbitration agreement apply? And the answer to that is no. That means that that party is saying, I'm abandoning the right to move forward with arbitration.
Well, not necessarily. Not if there's some provision of the policy, which is what they claim, that says in these factual circumstances it doesn't apply.
And Justice Larson, I would say the lower court rejected that as a disingenuous argument, and it is a disingenuous argument because...
Well, it doesn't make any sense because the trial court said, here the parties agreed the arbitration agreement exists, but that it's not applicable. It would seem inconsistent to waive an agreement that is not applicable. Yeah. So what does that, what does that mean?
Here's the factual explanation I wanted to get to, okay? There were 3 different groups of parties in this case. There was Nexteer, there was Mando, and there were individual defendants.
Okay.
Okay? The court created that special box not applicable because of that unique situation. Mando and Nexteer could waive the arbitration agreement because they were parties to the arbitration agreement. The individual defendants could not waive the arbitration agreement.
You are resisting the notion that maybe the trial judge ought to make this determination, whether it's an express or implied waiver?
I think the trial judge has already, Your Honor, rejected each and...
He rejected... there was a waiver. This judge thought there was a waiver.
Yes.
I think he thought the waiver required prejudice before he could avoid them withdrawing. So the question, there's a legal question that I asked initially.
Yes.
Is prejudice required for an express waiver? That's one to aside. If it doesn't, then we have the questions I asked next. Do we have an express waiver here? You think that there's only one answer to that question. I think there's some question in our own minds whether that is something that is as clear as you think.
And to compound it, if it's a legal determination, not a factual determination, don't we get to make up our own minds about whether there was an express waiver or not?
Yeah, I think there's 2 answers to that question, Your Honor. First of all, I think when a judge is actually drafting a case management order and he's holding a conference and he's getting the opinion of everybody and he's sending it out and he's saying it is so ordered that there should be some deference given to the trial court judge in determining...
But you seem to be resistant to my suggestion maybe this trial judge ought to figure out what he was doing, what the parties were doing.
Here's what I would say, Your Honor. It is one option for the court, which would be a legitimate option, for the court to instruct the trial court to make a very specific determination of whether or not there was an express waiver. I think, when I read the court's opinion, I think the court got right to the brink of saying that.
He was not impressed with the arguments being advanced for rescinding whatever that was on that order. He was not very impressed with the arguments that he was being asked to do that. So I understand that. But
right.
Isn't your best argument at this point on the question of whether an express waiver requires prejudice or not?
I think that is true, Your Honor. And if it does not require prejudice, then they waive the right to arbitrate. And
if there's an express waiver.
If there's an express waiver. Yeah, Your Honor, if in fact it is not clear.
No court has found to this point, right?
No court has specifically found that there's an express waiver, other than the Court of Appeals found there's an express waiver. And I thought the Court of Appeals opinion regarding the express waiver was well-founded. I mean, I'm not quite sure, Your Honor, when you agree to a court order that says, I stipulate to something, and I don't know what else it could mean when someone says that something is not applicable, when you're in a court of law and it's so ordered and it's after contemplation and you say an arbitration agreement is not applicable. I don't know what else that could mean other than we are not going to proceed with arbitration.
Said you can't waive an agreement that's not applicable. So then, I don't know what that
We
means
don't know what
either.
that means either.
To your question, I wanted to get back to your question, Justice Larson, because we didn't really highlight this in our brief enough. If you look at footnote 4 of the lower court's opinion, footnote 4 explains why he created the box of the trial court's opinion. And it basically says that because this was a collective agreement among 3 parties, that he needed that box instead of the waiver box because the individual defendants who were the employees were not parties to the agreement, so they could not have waived it. So in essence, he's saying
But is he relating what's in his mind? Because when the box on paper, when the parties sign off on it, is at that point words on paper. So how are we to conclude that your opposing party didn't think that it wasn't applicable because the agreement specifically carved out preliminary injunction proceedings, which were the very type of proceedings at issue at that time?
There's two different answers to that, Your Honor. First of all, our complaint said this is for money damages beyond preliminary injunction. The scheduling order.
I got you there, but at that
Right.
stage of the proceedings where this order was drafted, I thought the only topic of discussion is, are you going to give us a TRO or not?
It wasn't the only topic of discussion, Your Honor. It was one of the topics of discussion. And then the court was also
I mean,
setting.
there wasn't even an answer filed, right? So there couldn't have been.
There wasn't an answer filed, but there was a scheduling order issued where we talked about a jury trial, where we talked about scheduling and all sorts of other things, and the complaint itself said that there were money damages, and the actual CMO said there were money damages.
No, I don't dispute that. I'm
Yeah.
just talking about that. You couldn't claim arbitration and say, Judge, don't answer the question about preliminary injunctions because we have an arbitration agreement.
Right,
No
but
one can make that claim, right?
I think it's just revisionist history, Your Honor, and the judge was there at the time. Because what they also could have done with the case management order is they could have checked the box saying the arbitration agreement will be subject to a motion at a later time. And they didn't do that. And one of the arguments that amicus made and the defendants made is that because this is in a case management order, this is different. I think because it's in a case management order, it's even more stronger evidence of a binding waiver, because you can have a waiver. One of the cases we cited where you have a fax or an email.
Let me ask this question. Well, so your counsel says, your opposing counsel says that that the law requires prejudice even if there's an express waiver. Why shouldn't we?
Well,
So how are you harmed if they get to invoke the arbitration clause?
I think, Your Honor, you should look at this just like the Cabinetry case looked at it, just like some other case looked at it, that there's nothing wrong with basically holding an adult accountable, holding a party accountable for a stipulation that's been made in the case, right? Look, just like an ordinary contract. An ordinary contract, the court doesn't sit there and weigh who was harmed more or what happened. It enforces the contract. And that's exactly what we're saying the court should do here. The other thing that's the problem with prejudice, Your Honor, the other problem with prejudice is it'll create a further lack of clarity and a further inconsistency. If the court read some of the cases that talked about what's prejudice and what's not prejudice, they're all over the board.
Oh, yeah,
in those
that was my
cases.
next question. How much would you have to show in order to show prejudice?
And that's a great question, Your Honor, because the courts are all over the board. There are some cases that say that we cited, say a motion to dismiss, like happened in this case, where the court got rid of 7 out of our 9 claims, is enough to show prejudice, because if arbitration was the appropriate way, it should go to arbitration. And actually, in this case, international arbitration, in our view, they couldn't have dismissed the claims. So we were prejudiced in that way. Some courts, though, say 2 years of litigation isn't sufficient prejudice. So if we're looking, one of the things I think this court should be concerned about, if we're looking to create consistency and clarity, including prejudice in the definition as a requirement for an express waiver, does the exact opposite. If you want clarity and consistency, just basically apply the express waiver.
Counsel, I just have a question.
Yes.
I always like to try to kind of simplify things. So help me to understand.
Yes.
Why in this situation would the company not just simply evoke arbitration from the beginning? Why are we even in this spot having this conversation, having to make this determination? Why isn't this something that's done from the beginning, and why is it allowed that you can ultimately begin litigation and then ultimately then start to say that I feel that we should move into arbitration?
So we started the litigation, Your Honor, and the reason we started the litigation and filed it in court is, number one, we felt like the arbitration agreement didn't apply, and primarily that's because the main claims were against the individual employees. We had separate contracts with the individual employees that didn't have arbitration agreements. So to your point, Your Honor, we started the case in court. They waited 6 months to try to bring it to arbitration, and if there's any time when a provision that determines a forum should be given more weight, it's at the beginning of the case.
Right, so my question is, why would they have, what would your analysis be in terms of what would your impression be as to why would someone wait instead of evoking arbitration from the start?
Well, in this case, I can't tell you what's in their mind, Your Honor, but in this case, what happened was we had 7 out of our 9 claims dismissed that could not have happened in arbitration. So from a strictly strategic point of view, they benefited by waiting because they had a judge do that, and then we had to go to arbitration with only 2 of the claims left.
So, no, go ahead. I mean, you seem to want us to, your argument is we got to stick to the 4 corners of the document.
Yes.
I just have to ask, this says the agreement shall be construed and the legal relations between the parties shall be determined in accordance with the substantive law of Switzerland.
Yes.
Yeah, so are we supposed to apply Swiss law here?
That is exactly our point, Your Honor. That's why we didn't want the case to go to arbitration.
Yeah, but that's what your contract says. Your contract says
Yeah.
this agreement shall be construed and the legal relations between the parties shall be determined in accordance with substantive law of Switzerland.
Yeah.
Nobody's talked to me at all about Swiss law.
And that was never brought up at the trial court level, Your Honor, other than the fact that we said how ridiculous this would be to have Swiss law decide this case.
Well, except that's what your contract says.
Well, it's not, we think the contract's not applicable, Your Honor. I guess under the Federal Arbitration Act, which we said applies,
But
and under...
it's not just the arbitration provision, right?
Yeah.
Isn't that the choice of law? Is
I
that
think
the choice of law provision
I
for the
think-
whole contract?
It's a procedural issue, Your Honor, in terms of you're in the state of Michigan, the case is being filed, and I think the procedure in the state of Michigan and federal law, since this is a contract of interstate commerce, would apply to the issue about whether or not the arbitration provision should apply to send a case to arbitration. One thing, too, Your Honor, that I wanted to point out is, and I know my time is up, I'm sorry, all the cases and the statutes that talk about arbitration, all they say is that arbitration should be given the same weight as any other contract. That's all they say. So all this argument about, hey, revocation, et cetera, all these special rules that apply, they don't apply. All arbitration contracts are just like any other contract.
Thank you, Mr. Berman.
Actually, really quick, do the facts of this case, counsel, do they make this jurisprudentially significant, or does the specificity of the box and the specific facts of this case kind of alter its significance in pertaining to its jurisprudential value to us?
I think that the jurisprudential value to it is, I think this court would be well served if there's an express waiver not to require prejudice. So I think the facts of this case are unique, like every other express waiver case, because very few of them get to court. The facts of the case are unique. But I think the overall jurisprudential issue, Your Honor, of whether or not you need prejudice for an express waiver, I think that's something the court should consider. And I would ask the court to look at the Parsons versus Halliburton case, because that was just 1 year ago where the West Virginia court struggled and grappled with the same issue.
Any further questions? Thank you, Mr. Berman.
Is the CMO actually in the materials?
Yes, it is. It's, let's see, it's Exhibit O to Mando's application for leave to appeal.
Thank you.
Thank you.
I think you have about 35 seconds to go.
35 seconds. And I'm going to make this quick. First, not true that no case is found that you have to have prejudice when there's an express
counsel,
waiver.
we just need you to enter your name, please.
I'm sorry, John Birch on behalf of Mando. That's the Ninth Circuit case in Van Ness Townhouses cited at page 20 of our supplemental brief. On the CMO issue,
But that's dictum, right?
I don't know that it's dictum. I think it's part of a carefully crafted holding on prejudice.
Okay, good.
But quickly, on the case management order, Justice Bernstein, you're right. That's something serious. But the court will specifically say that you can amend the CMO because things happen. And what the Parsons case and the Caventry case that they cite say is that it takes time.
I got to tell you, my question is, and we always love having you here, so I'm glad to see you. But here's my question, though. Why shouldn't it constitute, if you have a CMO, why is that not a specific express waiver? I mean, what else is a CMO other than basically the roadmap for ultimate litigation?
Two reasons. In Caventry, the Seventh Circuit explains that it's not always clear at the outset of litigation. It might take 6 months or longer to figure out whether something is arbitrable. And as a matter of fact, that's exactly what happened here.
If that's true, being a good lawyer, you never say, as to a procedure like an arbitration that you're not sure whether it applies. You never say, there is one, but it doesn't apply. You say, I have yet determined that, and I would like to address that at a later point.
Sure, and that would have been a cleaner way to do this.
No, that would have been the professional way to do it.
It would have been cleaner, but the main...
Certainly that.
The main
but you don't
point-
potentially give away your client's legal rights unless you've researched them and you've concluded that something like an arbitration doesn't apply in the particular instance.
Sure, but as far as the legal rights are concerned, and this goes to giving all contract provisions and their waiver the same weight. This goes to consistency and clarity. What this case demonstrates in the context of the CMO and all the other cases that have been cited is that it's really difficult to say when you have an express waiver, when you have an implied
Well,
waiver,
let me ask you this
when you've got one
question.
by conduct.
Given the argument your co-counsel made, that prejudice is always required.
Yes.
It's a matter of indifference whether your predecessor counsel had checked the waiver box, the explicit waiver box, or this one.
In the same way that it would be
Isn't that
indifferent.
true? If
is.
it was unequivocally an express waiver, the argument would be the same, that Mando was entitled to withdraw it.
Yes,
Okay.
just like the case would be the same on the other side if no box had been checked. And the reason why we don't waive prejudice in the context of a waiver of any clause, but especially in arbitration, is that sometimes mistakes get made. Real simple hypothetical. Complaint gets filed. It says in one of the allegations that there is no arbitration clause. That's wrong. But opposing counsel answers, yes, that's correct. They file it in the trial court, in the business court. 5 minutes later, realize that that's incorrect, and they file an amended pleading.
Right.
Under their position, they say, well, it's forever waived.
No, it's not forever waived, but there's a process to undo the waiver.
They would say express waiver cannot be undone. That's their position.
No. The question is whether you have to show prejudice before it's effective.
That's it. They say we don't have to show prejudice. They say
Yes.
as soon as you file the answer that says there's no arbitration clause, that's
Right.
the end of the inquiry.
Unless you get the court to allow you to amend your answer.
Even in that case, they would say the express waiver's already happened.
Are there any
And so
facts
all-
in dispute on this issue of whether or not there was an express waiver, or is this something that on appeal can be found as a matter of law?
I think whether there's been an express waiver would be a factual determination. And I think the best way to read the trial court's opinion is that there was no express waiver here, that the parties were confused about what was happening. But I don't think you need to
So we
answer
should
that.
remand it back?
Yeah, I don't think there needs to be a
understand your
remand.
conclusion. If we think there was no, it's a factual matter, and that the trial court didn't make a factual finding, then you're inviting us to remand it back to the trial court to make those
No.
factual findings.
Because I think you should resolve it at the threshold level. If this court would say that the arbitration waiver always depends on whether the waiver is express or implied or something else, that's not a clear rule. When you've got Williston, 3920, the restatement of contracts,
How come no
84-2.
court has ever figured out this obvious answer from all these erudite,
Because,
esteemed
and that goes back to Justice Young's comment, that this area of the law is kind of a mess, and you can fix it. The reason is because courts throw around this.
Isn't the Ninth Circuit case kind of an outlier? I mean, it really talks more about an implied waiver more than
It's not an outlier, because I don't want you to think about contract waiver and retraction of waiver simply in the context of arbitration. I mean, you could create a more stringent waiver rule here because of the plain language of Section 6 of the Michigan Uniform Arbitration Act, which says this is irrevocable. In other words, unless it fails of its essential purpose, it cannot be revoked. But just under ordinary contract principles that apply not only to arbitration but to everything else, you can't have waiver without prejudice. And even though the other courts have all talked about this notion that because we favor arbitration, we're not going to lightly allow a waiver to take place.
In the abstract, without arbitration, the Federal Arbitration Act, why does waiver require a showing of prejudice? This is a matter of doctrinal...
Because it is bedrock contract law that waiver can be retracted unless you can show prejudice. And the reason is the one you articulated in Quality Products. Now, I know it's a different case.
That wasn't a waiver. That was a
It was an amendment.
contract revision.
Exactly. But the principle that underlies that is that when parties sit down with their transactional lawyers and they negotiate a written contract that spells out everybody's duties in exacting detail, then unless they sit down and they do that again and they have another amendment to that contract, we're going to honor what the original contract says, even if somebody makes a mistake along the way or says something that they shouldn't have orally. And the same thing applies.
Really? That's what quality said?
I mean, that's the way I understand the reasoning there, that we don't want to lightly infer. I know. I'm trying to read your mind. I don't think we want to lightly infer.
Apparently, I can't read my own.
We don't want to lightly infer that a carefully negotiated contract has been rewritten because someone said something that they shouldn't have, that wasn't consistent with.
Right. Unilaterally changing is different from waiving.
Well, not just unilaterally changing, but
My contracting
inducement.
partner can't impose on me a term that I didn't agree to, but I can waive a term I've agreed to.
Sure you can. But again, Williston.
Without prejudice?
Williston, Restatement, Farnsworth, UCC, all of them say you can always retract a waiver unless you can demonstrate prejudice.
Thank you.
And I don't want you to become the first court in the country to go the other way on that issue.
Mr. Marsh, I got to give you one.
Can I just jump in? 'Cause
Yeah,
it
go ahead.
it
Go.
invoked what I had been asking about. You don't want us to be the first court to go the other way on the issue, but you want us to be the first court to go your way on the issue. Is
I
that
want
right?
you to be
Do I have that
the
right?
first court to apply the overwhelming authority that says there has to be prejudice.
Right.
But I want you to do
Is there
it,
any court that said that? Your co-counsel said there was one, but she wasn't able to call it
and
to
I
our
can't come up
attention.
with that name either. But what I want you to do,
Wait, isn't that your Van Ness case?
the Van Ness is
No,
the
they
one that
never did
says
what
you
he
have to
said.
have waiver even when it's expressed.
I see.
I'm sorry, prejudice even
So
when it's
this
expressed.
one insightful, wise court that exists somewhere in the United States, will you please follow up with us and provide to us?
I
a
will.
citation?
I want this court to be that wise court
Forward-looking. Well, we're
and,
gonna be
and bring
following.
a semblance of order and clarity, not only to contract law, but to arbitration waiver.
I just, before you
I
go away,
apologize.
I'm
Yes.
sorry, but you have this Van Ness case from CA9. They have cabinetry from the Seventh Circuit
Yes.
and the Second Circuit case. Okay, I want to give you 30 seconds to tell me to distinguish those two.
Cabinetry, if you look at all the authority, is the minority position. And Cabinetry says...
Wait, how is it the minority position? They seem to have two, you seem to have one. It seems like the majority position.
Well, on pages 16 and 19 of our brief, we cite a lot more than...
But they're not an express waiver.
Well, so many of the cases don't draw the line. They just say
Exactly.
there was a waiver. Right, which is why you shouldn't require the trial courts to do that. But briefly on Cabinetry...
So a
Judge-
doctrinal confusion should become mutated into the doctrinal principle?
No, not at all. I just finished
Go
my
ahead.
answer to Justice Larson because I hate to leave you hanging there. In Cabinetry, what Judge Posner says is sometimes at the outset of a case, it's difficult to tell whether the arbitration provision applies. Perfect example here, where they file for preliminary injunctive relief and they underline the exception that says arbitration doesn't apply to injunctive relief. Sometimes it takes a while. I mean, that's the part of Cabinetry that makes sense. As far as the doctrinal confusion, the majority rule is you require prejudice. And if you follow the Restatement, Williston, Farnsworth, the UCC, all you're doing is aligning yourself with all those other cases, but doing it in an intellectually honest and academic way that makes arbitration consistent with every other area of contract law. And it eliminates situations like the hypothetical I described, where after 5 minutes you realize you made a mistake, but now all of a sudden your right to arbitrate is gone simply because you said the wrong thing in your answer or you checked the wrong box.
Mr. Bursch, you've covered a remarkable bit of ground in 30 seconds. Thank you very much.
Thank you, Mr. Chief Justice.